Funding your trust and why it's so important. Hi, I'm OC Estate Plan Lawyer Michael Pevney. You can reach me at ocestateplanlawyer.com. Click on the link to set up a free 30-minute estate planning strategy session. Today we're talking about funding your trust and why it's so important. Hopefully, you've decided if it's appropriate for you to create a revocable living trust. And when you create that trust, you write all the rules about how your property is to be distributed if and when you pass. But if you don't actually put stuff into that trust, put your property into that trust, it's almost meaningless. A trust can be thought of a little bit like a bucket. So when you create a trust, you create this empty bucket. Into the bucket goes the rule book, and that is all the terms of your trust. But you have to get stuff from outside of the bucket to inside of the bucket. The first most important thing to get inside of that trust is your home, your primary residence if you own a home. Remember that if you have an estate that adds up to $1 million, not taking into account any mortgages or anything like that, you can be paying up to $50,000 in probate fees if you pass away. A large majority of that being from your house, your home, your primary residence. When your estate passes by trust and not probate, all those probate fees are avoidable. And probate is expensive, it is extremely time-consuming, often up to a year. It is a public process, you lose the privacy, and you don't have a lot of control over how those assets are distributed, especially if you have minor children and you want those your estate distributed the way you want it distributed, possibly over time and under certain conditions. So to get a house from outside of a trust to inside of the trust, a deed is drafted. Any qualified estate plan lawyer can draft a deed. So for me, I would be transferring it from me, Michael Pevney, to Michael Pevney as trustee of the Michael Pevney Revocable Living Trust, dated August 6th, 1994, or whatever date you created that trust. It's a relatively simple process. You still have control over your home. You can buy it. You can buy more homes, put it into that trust. You can sell your home. You can get another mortgage on the home. So a home is very important to get into that trust. So many people create a living trust and they don't put their home inside of it, which almost defeats the purpose of having a trust altogether. Second thing, bank accounts. Most bank accounts should be titled under your trust, checking and savings accounts. Typically this has to be done, you gotta physically go into the bank and talk to somebody about it and fill out some forms, putting the name of the bank account, checking or savings, joint account between you and your spouse into the trust. You still have control over it. There are a couple of financial institutions, more and more are starting to do this. Some of them you can do it online, but many of them you still gotta physically go into the bank and do that. You have to present them with either a copy of the trust or something called a certificate of trust, which should be included with most estate plans. The certificate of trust basically tells the bank that you wrote the trust, you have control over the trust, it is revocable, that the trust essentially is a stand-in for you and you have total control over it. Shouldn't be that difficult to get that trust, to get that bank account into the trust. Next, brokerage accounts and investment accounts. I'm not talking about retirement accounts here, I'm talking about what's often referred to as a taxable account. Schwab, Vanguard, E-Trade, whatever brokerage house. You can get those accounts also into your revocable living trust by filling out some forms, and then you have control over that, and then all of those accounts, they'll never have to go through probate. Next, retirement accounts. This can be a little bit tricky because when you create a retirement account, whether it be an IRA or a 401k, a trust cannot be the owner of that retirement account. The I in IRA stands for individual, so you can't title those in the name of the trust. But what you need to think about is the beneficiary designation. Those accounts will not pass through probate. They don't have to pass through probate if they have the proper beneficiary designations on them. These can be a little bit tricky and you need to consult with a qualified estate planning attorney to understand what your beneficiary designations should be. Oftentimes, families with minor children might want to put their spouse as the primary beneficiary and then the trust as a secondary or alternate beneficiary. The reason for this being that there have been some tax law changes recently and you have to start getting the money out of those accounts once you pass away within a certain period of time. But if you want to have control over those assets being distributed to your kids, you might want to have them in the trust, although there will be some tax consequences to that. Personal property. It's not very difficult to get personal property into a trust. I'm talking about electronics, furniture, clothes, all that stuff. They are not deeded property. You don't hold title to it with any sort of document with your name on it that you've signed. I'm not talking about a sales receipt or anything like that. So typically you have an addendum to your trust. So when you create the trust, you say, I place all my household goods and personal property into the trust. That stuff's in the trust. Cars, also not that difficult to get into a trust, and also not that difficult to pass outside of probate. There are forms at the DMV that are not that difficult to get your vehicle into your trust. Life insurance. Life insurance also does not go through probate, and you also need to be careful about your beneficiary designations on life insurance. They are not subject to estate taxes. You might want to have the beneficiary be your trust, or possibly a spouse as a primary beneficiary and the trust as a secondary or alternate beneficiary as well. So those are a few reasons why it is absolutely essential after you've created a trust to fund that trust. You've got to fill that bucket up with all of your property and all of your stuff so it can be distributed according to what you want. The whole point of an estate plan is that your wishes are carried out. And without properly funding your trust, that's not going to happen when you pass away. Thank you for watching. This is OC Estate Plan Lawyer Michael Pevney. You can contact me at ocestateplanlawyer.com to set up a free 30-minute estate planning strategy session. Once again, thanks for watching.